Hello and welcome. My name is Jason Castillo. I'm the Director of Legal Education with Attorney Credits. Thank you for joining us for today's micro seminar on e-discovery and e-Competence. So 4 parts of today's micro seminar, and of course I'm not going to tell you everything you need to know about e-discovery in 10 minutes. This is more like your law school exam. It's going to be a little bit of issue spotting. So things you need to be aware of in your own practice. Maybe you can take these points to heart and bone up on some information if you need a little help with your early case assessment, native files, cost burden, things of that nature. There's a lot of room for knowledge here, so you can visit our website or please get the knowledge if you need it. But what we look to take home from today's micro seminar are 4 main points. E-discovery, basically what is it, who does it affect? Secondarily, where is this volume of electronically stored information, the information gold mine as they coin it? Third, we're going to get into the regulatory response of the federal rules, and then lastly, we're going to just hit on some practice points for you to take home. So first of all, e-discovery was kind of ushered in by the 2006 amendments to the Federal Rules of Civil Procedure. Obviously, things have been going on before that with cases like Zuba Lake, and there was a Sprint case in Kansas from 2005. So there were a number of cases that dealt with these electronic issues before the federal rules. The federal rules looked to harmonize everyone, put everyone on the same page. Everyone knew what to expect. So even if you don't practice in the federal courts, the federal rules of evidence have crept into many state codes. And in fact, over 25 states at this point in time have adopted language similar to the federal rules, including the state of California, in which we're located, which adopted rules just a few months ago. So you've definitely got to be up to speed on that. So, now e-discovery, who does it apply to? Obviously, if you're the general counsel for a Fortune 500 company, you're going to have to be able to locate a massive amount of evidence. That's going to include anything in the corporate infrastructure, communication infrastructure. So that would include instant messages, text messages, anything on the corporate computer. It might include calendars, maybe a program like Microsoft Outlook. Any type of electronically stored information inside that Fortune 500 company, you're going to have to be able to institute a litigation hold, not even when the lawsuit begins, but even with the possible threat of litigation. So again, Fortune 500 counsel definitely have to worry about these new rules to the Federal Rules of Civil Procedure. But even if you're a solo practitioner or you work at a small firm, you definitely have to worry about these things as well. And a Virginia case really drives that home. Basically, this was a divorce case. Husband and wife, at the conclusion of the case in which the husband was awarded sole custody of the children, the husband or the wife walks into a digital expert's office and says, this was something fishy going on. There was some emails sent that the husband said I sent, but I didn't. Here's this computer. Can you take a look at our computer and see if you can come up with anything? Well, of course, right off the bat, it looked like there was, something fishy once he got right into the operating system. Took him probably less than a week, and he had already uncovered the fact that the husband had gone in, opened up a Yahoo email account, and done some different bits and pieces, so basically a little identity theft as well, and created an email account in the wife's name in which he used to send those incriminating emails, which forced the judge to award sole custody of the children to the husband. So with that evidence in hand, obviously, the judge ended up changing his ruling drastically. But what this case drives home is, even things like email have to be authenticated in certain trials. Especially if you're in a multi-million-dollar dispute, maybe a real estate dispute or something like that, you have to authenticate these emails. And e-discovery is not just for the general counsel or some, lawyer for some massive company. Everyone has to be versed in these procedures. And this Virginia email case, the divorce case, really drives a few points home. First of all, what the hell was the lawyer doing? If this doesn't rise to the level of incompetence, I don't know what does. The wife has to walk into the digital evidence expert's office at the conclusion of the trial. So A, the lawyer completely missed the fact that they needed to bring somebody in to authenticate those emails. Two, they didn't even bring the expert in at the proper time. And that's another point that this Virginia case really brings up, is that the further we go into this new digital millennium, in fact we're already in the year 2010, attorneys are going to be held to a higher and higher standard. I know that many of us are not tech savvy, and for the most part many legal practitioners have ignored the massive volume of electronic evidence out there. but we're only going to be held to a higher and higher standard. As more judges take the bench that are versed in these electronic issues and more attorneys become savvy, this is just going to become part of the practice in law. And indeed, I've even heard for some circles calling the dropping of the E off e-discovery, because in fact, and this kind of leads right into our second point, the massive amount of information out there that is stored electronically. So just to drive it home, this is from about 2007, 3 years ago. There was a website, basically a data website, that said that the amount of data created in 2010 would be 988 exabytes. Now, I have no clue what that means, but 1 exabyte is 1 billion gigabytes. So that's 988 billion gigabytes of electronic data. And this was an estimation in 2007 of what 2010 would look like. They figured that there would be 988 exabytes of data transferred in a whole year. Well, according to the Digital Britain report, there were 500 exabytes of data transferred on June 15th, 2009. So even from what they thought the volume of electronically stored information was going to be 3 years ago, it's just bumped through the roof. So obviously it's out there. From the corporate infrastructure, any type of digital device, you've got to think about what you got out there. Obviously cell phones, people use these more and more. Text messaging has become huge. There were 4 billion text messages sent in 2009. That's double what was up from 2008. Obviously you've got laptops, computers, any other type of communication device. But you would also think about stuff on the hard drive or things that are out there in cyberspace like Facebook pages, operating systems, electronic devices, Blackberries, cameras, cell phones, listserv, websites. I've even heard of GPS being used as electronically stored evidence. So the take home on this is if you're not versed in these issues, something like Qualcomm versus Broadcom can happen to you. Now, you may not be involved in a billion-dollar patent dispute, but in that case, the lawyers for Qualcomm failed to produce 46,000 emails and were greatly admonished by the judge, sent to the state bar. Qualcomm was fined $8.5 million, and a number of the attorneys that were working for outside counsel, and I think inside counsel as well, were suspended for 2 years, fined. So again, it can be huge repercussions if you don't know where this digital evidence is.